Hello. Am I audible until the back? Okay. चलो, तो all of you have the handout? Handout है? नहीं है? किसके पास नहीं है? I believe you might have taken the printout, right? Okay, makes sense. So we are meeting today for the voice. Saurabh, voice का issue है. It's fine. So offline people are complaining about the voice. Let me just get it done. Online, is it good for you? ठीक है. Is it good now? Better now? Okay. So we are meeting today for the administrative part of the polity. In the last class with Amritan sir, you did the constitutional part of the polity. ठीक है. The administrative part, beta, please settle down first. आदत नहीं है ना क्लास टाइम पे स्टार्ट करने की. So today's class will be on administrative part, and when I say administrative part, generally this will contain 4 different heads. Those 4 different heads are, first of all, judiciary. Second is elections. Third is the third tier, which is nothing but the local bodies. And the last head, which I will be dealing with you, is bodies, where we have 2 sort of bodies. Those are nothing but constitutional and non-constitutional bodies. Okay? So these are the 4 different areas on which we have to focus in today's class. Now, one very important thing, that if I divide the PYQs into these 2 classes, generally there are 50 to 60% PYQs from the Polity 1.2 and 40 to 50% PYQs are there from the lecture 2.0. Generally you will find almost 4 questions from this lecture, 4 to 5 questions from the lecture number 1, right? So in today's class, the majority of the time will be going into the judiciary, then elections, then local bodies, and the least time will be given to the bodies. I will tell you the way out, right? So let's start with the judiciary first now. Again, if you can see your handout, all of you have the handout. The very first page of the handout is completely blank, right? That is generally how I deal with the topics or the heads. On the very first page, we will write the general content, the content and the frameworks which we can replicate across the topics. ठीक है? एक basic understanding we will take about the topic, right? So just do not write anything as of now. अभी कुछ नहीं लिखेंगे. When I will ask you to write, you will write, and I will dictate some part of it as well. ठीक है? The first thing, if I talk about Indian judicial system, is nothing but the challenges in Indian judicial system or the issues in Indian judicial system. ठीक है? Now, if I want to ask you the issues, how we think upon the issues for any organization whatsoever, see, we have to deal with bodies, constitution, non-constitution. So this very first page, whatever you are doing with the judiciary, as it is, will be replicated in the bodies and non-bodies. And if you can sense, the framework will remain the same. It's just some of the facts, the basic features, the what is the this what you say, the function of the bodies will change. That is the only change, right? But the entire framework will be replicated. So you need to be very attentive on this, that what are the challenges in India's judicial system. But I am giving you 10 seconds, please settle down. Fine. Okay. See now, if I am talking about any body whatsoever, be it in IR, be it in environment, be it in polity, any body, let's say SUNYA IAS as an institution. This I have already dealt in my mark basic. If there is issue in any body or the institution, judiciary is nothing but an institution, right? The framework which you have to use is simply just see how we create a body, what makes a body complete. First of all, if I see this SUNYA IAS as an institute, what I need here? I need here, first of all, the appointment. That first of all, the people will be appointed. There may be some issues in the appointment, right? Maybe some of the seats here of maybe counselors or maybe marketing is empty. That could be the issue. Okay. The first and foremost thing in any organization whatsoever is the level of the appointment. With appointment, what you will do? Human resource. What you will bring on the table? Human resource. So the second issue will be at the level of human resource. That is, sir and ma'am, we will focus and we will comment upon the human resources. Maybe the quality of the the people at SUNYA IAS, you don't find it apt, right? Maybe the work delivery is not apt. What I'm saying, on human resource you will comment. Maybe all of the people hired in the SUNYA IAS are males, so we'll comment upon the human resources, the quality, the features of human resources. Third thing is, and this framework again I'm repeating, at least will be applied in 2 questions in mains. GS 1, 2, 3 में मिला के 2 questions में at least it will be applied, because 2 questions are there all the time, every time from the bodies, be it in GS 1, 2 or 3. Okay. Now, third thing is on which we will comment is nothing but the work delivery, the work they are doing. And fourth thing on which we will comment is nothing but the infrastructure. Understand now, in Indian judicial system, if I talk about the issues at the level of appointment, what are the issues? The first and foremost issue you can comment is the collegium system. Okay, fine. I will write this as the black box, or which is nothing but the collegium system. Or else there will be political interference. Or else in appointment there will be nepotism or the favoritism, which we say with the keyword as uncle judge syndrome, that the judge who knows the other judge will end up appointing them rather than appointing the people based upon the merit and the experience. So this syndrome, which is equal to nepotism, is nothing but uncle judge syndrome. Do not write, I will dictate, please do not write. Okay. So first I have done what I have done, I have commented at the level of appointment what are the issues. Here there is political interference. Whenever the judiciary is appointing, it is appointing through the collegium system. For those who don't know collegium system, I am coming to it. Collegium system, which is acting as a black box. Then the third issue is nepotism or the uncle judge syndrome. That is, the judges who are there at the position ended up hiring the judges which they know or the people which they know. So I commented on the appointment. Then I will comment on the human resource, that now the quality of people who are appointed. So first thing is corruption, and generally at the level of lower judiciary. For example, you have the recent Delhi High Court judge, okay, burnt cash case, है ना, Verma, Justice Verma. Then on the human resource, when you are commenting, you will write about poor women representation in judiciary. So if I talk about women representation in judiciary, it is as low as 5% in Supreme Court till date, as low as 14 to 15% in High Court till date, and as low as 30% in the district courts or the lower courts. Okay. So poor women representation in the judiciary is second. So I have commented on the human resource, the people who have been appointed like on the benches. Now I will comment on their work. For example, those the judges who are appointed in work, what are the issues? Pendencies. So there are pendencies and the backlogs, and we all know justice delayed is justice denied. So what we have in the work delivery, we have the backlogs, or we have the pendency of cases, which is leading to delay in justice. Hayana. What else? Complex procedures. Okay. ठीक है. Fine. We got the idea. Points तो अभी देखेंगे. Idea मिल गई. Then infrastructure. What are the issues in the infrastructure? See, what we can write here is language barriers are there and all those things. ठीक है. Fine. What are the issues in infrastructure? Poor digitalization in justice delivery. Even if the digitalization is there, the judges are not compatible in delivering the justice. What else? Basic infrastructure for the disabled, infrastructure for the females, the toilets and all those things. But more technical points could be absence of Supreme Court in the different corners of the country. We have just one branch of Supreme Court, that too situated in Delhi. So what about the people from the south, northeast? They have to travel until Delhi to get the justice. Okay? So what I can write here is, I can write upon absence of regional branches. So regional branches, that is Supreme Court only at Delhi. Okay? Now you can add multiple points. For example, human resource, we can write about the All India Judicial Service is not available, right? In work delivery, we can write about the judicial overreach. That is also a point in work delivery. That is the issue in the work delivery, right? So that is how we can expand the topics now, or the points now. But the mindset remains the same. If there is any body which is coming, that is how you will think. Be it in IR, be it in any subject. First of all, appointment level पे issues, human resource level पे issues, what work they are doing, uske level पे issues, then infrastructure. Let's say you talk about NHRC. So NHRC में the framework remains the same. At least 4 points you have. Appointment में the political interference is there. Human resource में shortage of staff and there is poor training. Then when it comes to work delivery, generally it is termed as a toothless tiger. Okay? That they have the what is the verdict power that cannot be enforced by them, right? Then infrastructure may they don't have their own what is the offices and the independent what is the human resource or the infrastructure. So that is how we can generate the points if we have the framework ready. Do I make myself clear? So at the top, what you will do, in the center you will write challenges in Indian judicial system. Challenges in Indian judicial system. And please ensure we have to give 3 different sections. So whatever you are doing is should be maximum in the 40% of the space in your document. 40% पे आप लिखेंगे, then 30 will be divided. Appointment. First point is vacancies. Then around, see that is how you evaluate. थोड़ा सा tab difference you give. Easy is the tool which signify that we are which represent that we are evaluating. Around 30% in lower judiciary. Around 30% in lower judiciary. Then right, collegium system, in bracket opaque, in example value do termed as black box. by second ARC. अच्छा, when I will be taking your Eklavya, I will discuss the ARC report in 1 hour. ठीक है, what are the recommendation, different topics in Eklavya. As of now, second ARC, Administrative Reform Commission. 30, right? Nepotism or favoritism. Favoritism. Example, just do the validation with the keyword uncle, judge, syndrome. And exactly how this uncle judge syndrome is working, I will explain you this in the appointment. Okay, we will deal with the topic as the appointment. Then you write fourth point, political interference. Political interference. Example, right? NJC. In bracket you write struck down. This also we will deal as a separate topic soon. NJC will deal with as a topic. Okay? Just write and leave. Don't worry. Write and leave. A prominent thing. Then give a next, human resource. Write 5. Poor woman representation. Example, Supreme Court SE. That is exactly how you write, equals to 2 out of 38. So currently if I see the strength of Supreme Court, it has been increased. If you have followed the news, it's fine. Out of those 38, currently there are 2 female judges. Okay, only 2 out of 38. Sixth, alleged corruption cases. We'll do the validation as recent Justice Verma case. This I have discussed in the governance as well. Okay? In detail I have discussed the case in governance. If you missed, you will do this again in the governance wala class. Then mark it 1 star and write. I want you to remember this. If we are putting this point, the answer becomes more technical. Okay? Please write. No defined criteria no defined criteria for eminent jurist. No defined criteria for eminent jurist. See, in the constitution it is written that if we want to appoint a Supreme Court judge, there are qualifications given. Out of those qualifications, one of the qualification is president can appoint any eminent jurist as a Supreme Court judge. But now exactly who can be termed as the eminent jurist is not defined in the constitution. But let me tell you a pointer from the prelims point of view, that this clause has not been used yet. Till date, no eminent jurist wala clause has been applied to appoint the Supreme Court judge. There are 3 criteria you will see in the prelims. Done? Then write point number 8. Right? No homogeneous cadre. CADRE. No homogeneous cadre. Valid AIJS, AIJS is still not enforced. All India Judicial Services, don't worry, I have to deal with this entire topic. पूरा topic देखेंगे हम. So AIJS is still not enforced. So till date in country, if I talk about the district level ka judges, there is separate system for the separate state. So we don't have the homogeneous recruitment system like we have for the IAS. How we recruit the IAS? We have the UPSC CSE ka examination, right? So for judiciary, if I talk about the judges at the level of district judges, there is no homogeneous examination of the cadre for the entire nation. Okay. Now we'll see the pros and cons of AIJS in that topic. Next is, please write, transfer of judges. Transfer of judges. The value addition is sometimes politically motivated. Sometimes politically motivated. Done. Now we'll write here work delivery. Tenth. Please write backlogs. This is point number 10. Backlogs leading to delays. Example, 5 crore cases pending in DC and HC. In DC, DC is district court, SC is high court. Short form we are writing so that we can make the notes compact. In bracket you can write the source IJR. This I have discussed in the data and facts also, the class which I took, data facts, you might have seen it recorded. IJR 2025. IJR is, just write the short form. In data and facts you will see the like the long form. It is Indian Justice Report or India Justice Report 2025. Next point you write, please write expensive and costly example, lawyer fees and travel. Lawyer fees and travel. Next point you write, and see this now, just feel the point, mark it 1 star again. This is a technical point. Lack of specialization. See, you cannot expect the judges to know every provision of the every act. There are number of state acts, there are number of central acts, and sometimes going technical in nature. The acts dealing with the biotech industry, space industry, the defense industry, they will get technical in nature. They will have the provisions which are technical in nature, working mechanism, all those things. How can you expect the judge to know all those provisions? Are you getting my point? So sometimes it happens that in some of the cases there is lack of specialization when the judges are, sitting on the panel. Done. So for this, to sort this out, we have the different provisions now. We have the arbitrations, we have the tribunals, we have the fast track courts. So we'll see that as a part of the lecture. But there is an issue that sometimes the judges face the lack of specialization when they are dealing with the cases. Please write example. Example, need of tribunals. Next point you write. Wrong use of judicial independence. Wrong use of judicial independence or misuse of judicial independence. Example, judicial overreach. So today we will see the difference between the overreach, activism, review. Okay, I have to cover again this as the separate topic. They write about the infrastructure. Please write 14th. Poor digitalization or compatibility. See, at the first case, the courts are not digitalized. Second case, even if they are digitalized, the judges are not well trained to use those devices. They generally don't feel comfortable to maybe look at the camera or to open the camera or maybe the device, on it, schedule a meeting, get it done, all those things. So they need an extra supporting hand in that circumstances. Please write. Next point, 15. 15, please write. Poor basic amenities. In bracket, toilets or ramps. Toilets or ramps. Example, 25% courts do not have separate toilets. Do not have separate toilets. Then you write. Then write. Regional presence slash branches. Regional presence of branches hampering the doorstep justice delivery. Okay. So we can write the example as Supreme Court semicolon only in Delhi. Supreme Court only in Delhi. Are we done so far? I'm giving you 15 seconds, just go through it. If you have any doubt, do ask from me. If you're not understanding the collision system or maybe the uncle just it's fine. I will take all those topics in detail. But did you got the framework? Okay. And a piece of advice, whenever I am teaching you any framework, बेटा कौन बात कर रहा है इधर? इंपॉर्टेंट है तो बाहर जाके करिए ना, आप क्लास में कैसे कर सकते हैं? मैंने मना किया ना, आप क्लास में होकर बात नहीं करेंगे यार, और जब मैं बात कर रहा हूँ बिल्कुल नहीं बोलेंगे, तो फोन पे बात कर रहे हैं. चले, और आप डोंट बी ओवर स्मार्ट इन द क्लास यार, मैं आपसे बोल रहा हूँ, ठीक है? पहली क्लास है क्या आपकी? तभी आप ज्यादा बोल रहे हो, है ना? ठीक है. Whenever I am telling you the frameworks, just write the framework at the corner, highlight it. ठीक है? Because frameworks will be the tools which will help you to answer the bouncer questions. Ultimately, if I have taught you a framework, it is something which will simulate your brain. यार ऐसे सोचना है. ठीक है? So in today's lecture, whatever frameworks I am dealing, just write a framework at the top. I will tell you myself this is the framework. Write at the top framework, highlight it, so that if you want to skim through in 10 minutes, you are just skimming through the framework. ठीक है? चलो. Now, next framework. Again, this is the framework. The framework is about features of justice delivery. Again, in the next 30% of the space, we will give a heading, a straight heading, features of justice delivery. On the board now, on the board, लिख लो, फिर बोर्ड पे देखो एकदम. Be it any service delivery whatsoever. For example, education system, health, PDS, food as a service delivery, PDS system. Be it any service delivery by the government or through the governance, this framework is valid. Let's say transportation services as a service delivery. यहां भी service delivery का सवाल आएगा. Be it any question, this framework is valid. This framework we will see through the lens of justice delivery. ठीक है? And we will see what all components we can see use in the other topics as well. But the framework remains the constant. So if I ask you what are the features of service delivery, let me give you 3 features. First of all, justice delivery should be affordable. That is, people should be able to pay for it. Those who are from the vulnerable sections, they may get it for free. Affordable. Second is available. The justice should be available to my doorstep. I should not travel, let's say, 1000 kilometers or 2000 kilometers for the justice delivery. And there should be some mechanism through which I can get the justice. Right? For example, someone has broken the glass of my house. There should be a mechanism of justice delivery. है ना? For example, if I purchase something from the outside shop, we have a mechanism of the consumer court system. So there should be a system set up, available. Justice should be available. Third thing is accessible. Accessible simply means around my vicinity. Okay. What examples you can give me in these 3? First of all, in order to make the justice affordable, what we have done. Nalsa, those who don't know, just don't worry, we will see this as a separate topic. We have seen Nalsa, where the body Nalsa is providing the free legal aid to the vulnerable sections and even compensation to the victims. This means it is trying to make the justice affordable in nature. You might have heard about the provision that the criminals sometimes get the support of the government in order to get the lawyer, the public lawyer, the public prosecutor. Suna hai? So affordable. Then you might have heard about lok adalats, where there is no court fee. In order to settle a court case in the lok adalat, there is no fees. You just go, get yourself heard, you get your case solved. No court fee. So these 2 examples are the examples of making the justice being affordable. Justice being available. What are the examples? E-courts, fine. E-courts. Then we have the tribunals. Okay, mobile courts, fine. For accessible, what are the examples? Gram Nyayalayas, very good. Gram Nyayalayas. what we are doing is we are trying to bring the justice in the grams around the village. If you have any issue, go to gram न्यायालय, get it solved. You need to travel to the district court or maybe to the high court or supreme court. Gram न्यायालय with all the powers similar near to your house. Apart from this, now what else should be the feature of Indian justice delivery system? Does it make the justice delivery apt and appropriate? What else? Sorry, awareness is fine, but when I file a case, see, understand my problem statement. When I file a case, when you will see my justice delivery being just in nature, first of all, the next feature is nothing but quality. Whatever justice I am getting should be of quality nature. It should not be something someone heard me and just disposed of the case. Despite of being justice affordable, accessible, available. Affordable, available, accessible. If the justice is not of quality nature, again the justice is not complete, right? That means there should be some sort of expertise involved, quality involved. For this, what we are having? We are having the arbitrations. We are having the tribunals. ADR or arbitration. Okay. What else? Let's say on the board, all of them are working, but my case is stretched to 15 years. Is the justice justified? No. So the next ideal line is, if I want to see the feature is, I should get the timely justice delivery. My case should be disposed within a defined timeline. For this, we are having fast track. Fast track. Is it all? Is it all? What else is missing? Me, Sugam Bansal, went to the court. Everything was fine. I was able to access the things. I get the justice in one year. Timely justice मेरे को मिल गया. The quality was also great. The award sentence which I got is that Sugam Bansal should be given 1 crore as the compensation by other party. Is the justice done? What is missing here? Unless and until I get my money. That means the justice should be enforceable in nature. Now, the moment you add this, that the justice is enforceable in nature, this makes the justice delivery complete. That means right now there are provisions like Contempt of Court Act. Contempt of Court Act. Okay. So now see, remove all of this. Education पे लगाओ इसको. लग रहा है? Health पे. I think we have seen this in social justice. Apply this into PDS. Is it applicable? Apply this to any service delivery. Let's say transportation. Is it applicable? Applicable. So the idea is, for any service delivery, the framework is same. Affordable, accessible, available, quality, timely, enforceable. In some of them, enforceable may not be there, but in most of them, all 6 heads will work in tandem. Okay. What you will do in the next 30% space, you will write this along with the example. Again, a very important framework. Done. Chalo. The last we will do, it's not a framework, it's a general content which we can use maybe in the conclusion or maybe just before the conclusion, or maybe if the direct question is coming on the initiatives related to judiciary. Okay. So simply we are now seeing the initiatives taken to strengthen the Indian judicial system. Initiatives or the government initiatives. Okay. Now the framework which we will deal here is, those who don't know or those who have not seen my mark basic sessions, the framework which we will deal in this is about the, when I talk about any initiative, first thing which I am concerned is bodies or the institution. For example, if I talk about Indian judicial system, what are the bodies associated? First of all, you have 3 tier: district courts, high court, supreme court. Then you have other bodies, one name I took, just NALSA. Then you might have heard about Law Commission of India. Then you have the parallel institutions like Lok Adalats, tribunals, fast track courts, arbitration centers, Gram Nyayalayas. These are the parallel bodies working in tandem with those 3 levels. So we have the bodies of the institution, the initiatives taken to fix it at the levels of the institution. Okay. Second is acts. For example, Contempt of Court Act is there. For all of them, we have a separate act. We have the NALSA Act. We have the Arbitration and Conciliation Act 1996, amended in 15, 19 and 21. Then we have Mediation Act 2023. So these are the act. Then we have Judges Inquiry Act 1968, right, for the removal of a Supreme Court judge. Very important for those who are giving mains this year. I don't think anyone from the, we have the mains tomorrow. Then third will be initiatives or the schemes. Now schemes we need to divide into some various ideologies or functionalities. For example, there will be some schemes in order to make it digitalize. You might have heard about e-court system, Tele Law Initiative 2.0, LIMS portal of the this Supreme Court and the High Court, LIMS portal. So digitalization के लिए भी some scheme. We have some scheme for the infrastructure, है ना? For example, National Digital Data Grid, we have the infrastructure and the data. Okay. So that is how we will see the schemes. Done. So please start writing. Right here, first 3 tier: Supreme Court, High Court, District Court. Bodies of the institution for the justice delivery. Secondly, right, NALSA, semicolon, for free legal aid. NALSA for free legal aid. Thirdly, right, Law Commission of India. And for the lawyers, do you know anybody about the lawyers? Bar Council. Okay, you can write or add Bar Council of India. Again, this Bar Council is playing a very dominant role when it comes to the lawyers being appointed as the judges. Do you know, more than the the district judges being appointed as the High Court judges, lawyers are more than 50% lawyers are appointed as the High Court judges, rather than the district court judges promoted as the High Court judges. Lawyers ज़्यादा होते हैं. So very prominent role played by Bar Council of India. Then we have 4 different parallels. You will give us a heading here like this: parallels. Parallels. To this parallels, what are the parallels? Please write here: tribunals. Article 323A and B. We will see this as a topic. Article 323A and B, Part 14th A, 42nd Constitutional Amendment Act. Okay. Then you write लोक अदालत, ADR. ADR we will see as a complete topic, alternate dispute resolution. Then you write arbitration and mediation. We'll see the X here. Arbitration and mediation. And then you write Gram Nyayas. One more you can add is the fast track courts, FTCs. Fast track courts in India. So the justice, just to expedite the justice delivery, we have the fast track courts. Then write X. Please write. And please try to remember the year of them. I request. Okay? In prelims also we are getting a direct question related to year. And this I proved in the government initiatives wala lecture. If you know the year of the act, you are able to solve the question. I mean generally, the mains information helps in the prelims as well. So just try to remember the year of at least these acts, whatever I am writing on the board. Contempt of Court Act. Contempt of Court Act 1971. Judges Inquiry Act 1968. Arbitration and Conciliation Act 1996. It has been amended in 2015, 19 and 21. Okay, Arbitration and Conciliation Act. Then you write a very fresh act, Mediation. Mediation Act 2023. Then for this Lok Adalats and the NALSA as a body, we have a single act which is nothing but Legal Services Authorities Act or NALSA Act, National Legal Services Authorities Act 1987. For these acts I request please remember the years as well. Schemes, please write. First you write for the infrastructure. National Judicial Data Grid. National Judicial Data Grid. Then write Disha scheme. Second, Disha scheme. In bracket please add. In bracket please add. Innovative solutions for AI driven legal aid. AI driven legal aid. This we will see in prelims also. A very important Disha. Recently Disha 2.0 was launched. ठीक है, prelims में देख लें. Then you give a separate subheading. Legal assistance. So legal assistance means maybe the money or maybe the human resource, like giving the lawyer and all those things. legal assistance. Third, please write न्याय मित्र portal. न्याय मित्र portal. Then we have न्याय बंधु program. न्याय बंधु program. Then we have pro bono legal services program. Pro bono legal services program. All three are very important schemes. Two contributing to this. These two contributing to this we will see in prelims. Rest what you can do, go home, search about them. थोड़ा थोड़ा पढ़ लो अभी से, ठीक है. Then write a subheading again, which is digitalization. Sixth, please write tele law initiative. Tele law initiative 2.0. 2.0. Then write e-code project. E-code project. Then write LIMS portal. LIMBS. LIMS portal. In bracket you can write management of legal information. LIMS portal. In bracket you can write management of legal information. One from the prelims point of view, again you will write here is SUVAS. 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 Please write AI based translation tool of judgments. So people who face difficulty in order to read the judgment. Sometimes, for example, let's say if you are proficient, not that much proficient in Hindi, the judgment is coming only in Hindi. So to translate that in English or maybe the language which you know, we have the SUVAS initiative of the government. Okay? AI based translation tool for the judgments. Done. So we are done with the very basic aspect of the Indian judiciary or the Indian justice system. This is the basic. I'm giving you 30 seconds or 1 minute. Just go through it, skim through it. Starting se will go. Done. On the board now. On the board, please. On the board. Now we have to cover this. the appointment, the transfer, and the removal of judges. Majorly in the next 1 hour we will be hovering around these dimensions, or maybe women in judiciary, ठीक है, related to the same funnel. Appointment, appointment के बाद transfer, transfer के बाद removal. So we will start with the appointment first. If I talk about current system of the appointment, what is the current system? The current system is known as collegium system. Now, when I talk about this collegium system or this collegium system is something which is developed through a process. Okay. Let's understand that, and this factual information is important from a mains point of view as well. Whatever is important from mains point of view I will deal within the class, rest we will see in the prelims wala session as well. In prelims also the administrative part will be dealt by me only. Okay. So if I talk about the articles for the appointment, there are for Supreme Court and for High Court. What are the articles? Supreme Court के the article is 124 and for High Court it is 217. So with these articles the appointment process is mentioned but not comprehensively. So what happened in first judge's case, that is SP Gupta versus Union of India in 1982, this was taken to the Supreme Court. Please interpret these two and tell us. So Supreme Court said that the word recommendation mentioned in these two articles is not binding on the precedent. Recommendation is not binding on the precedent, and the consultation with the Supreme Court is not equals to concurrence. That whenever you want to consult that whether we have to appoint a judge or not, it is not concurring on you. You can appoint whosoever you want to still, even if you are recommended or you are not agreed to it. This was the interpretation in the first judge's case, which was in 1982. Then again this was taken to the second judge's case, 1993. The name is SC Association on this is Advocate on Record Association. Supreme Court Advocate on Record Association versus Union of India 1993 case. In this, Supreme Court then reversed its judgment, said this recommendation whatever we are sending to you is binding on you, and this consultation whatever is mentioned in the article 124 and 217 is nothing but the concurrence, that you have to listen whatever we are saying. Whatever names we are sending to you for the appointment of the Supreme Court and the High Court judges is binding on you, you have to abide by it. And this gave the birth to the collegium system. In the advice or the panel which will send a name, the recommendation will be sent by CGI plus 2 senior most judges. Okay. Again this was challenged, and when this was challenged in third judge's case in 1998, Supreme Court said whatever we said in the second judge case we abide by it, but a slight more reform, and the reform is the CGI plus 2 will be now CGI plus 4. So Chief Justice of India plus 4 senior most judges of the Supreme Court will now send the recommendation list. The list will be binding on the government, and the government has to concur on it. You cannot change the names, you cannot reject them. Okay. So just in third judge's case the collegium system expanded. From the prelims point of view, collegium system took birth in second judge case, not in third judge case. Okay. In third judge case CGI plus 2 changed to CGI plus 4. Now the issue in this, what was the issue in this? Major broad. The issue in this that whenever the judges, the CGI plus 4 are trying to appoint the other judges or send the names to the government, they will try to favor or send the name whom they know. Maybe a very prominent or the eminent lawyer which they know, they will send the name of that lawyer. This leads to the issues of nepotism, favoritism, which we know as the uncle judge syndrome. Second thing is, whenever we are talking about this collegium system, you see there is nowhere Supreme Court mentioned the entire judgment that what will be the criteria of the selection, what will be the rules of the selection. Do they provide any justification for the selection? No. everything is getting done in the black box. It is not being disclosed to anyone that why we selected those judges is the problem statement. There is no rule, no timeline, no justification, and no guideline provided by the Supreme Court. And they imposed this on the legislature. So, with time, by the various commissions, committees, and the critics, this was criticized that since this is working as a black box, people may lose or the citizens may lose trust in the process or maybe in the judiciary. So government took a step. Government tried to fix this through a legislation, constitutional amendment, and NJC. Through that constitutional amendment, government brought the NJC, National Judicial Appointment Commission. There are various issues in that NJC. The most prominent issue in the NJC was that NJC comprises of 6 members. Out of those 6 members, 3 will be judicial members and 3 will be non-judicial members. And out of those 6 members, 3 judicial, 3 non-judicial, even if any 2 veto, the process will halt. Any 2 veto, the process will halt. Now, whenever this veto is being done, don't you think that 2 people could be of the government? Non-judicial mein? So, the government, the executives have the power to halt the appointment of the judicial people through the NJC. So, Supreme Court considered this as the dilution of separation of power and the independence of the judiciary. So, Supreme Court through the 4th judge's case cancelled this and made this null and void. That since this is against the basic structure doctrine of the constitution, this stands null and void. 4 judges were supporting it, 1 judge was against it. NJC also brought to the 99 constitutional amendment, like some factual parts are there. Bas samajh mein aayi. So right now if I ask you what is the current situation, how you will answer? The current situation is this. And this current situation again has 4 basic parameters. And those 4 basic parameters are same. That there are no guidelines. There are no timelines. There are no rules. And then there are no justification being provided. See, there are some countries where the judicial members are selected through the online streaming of the selection process. Ab samjhiye, the interview is conducted over the online medium, TV or maybe this YouTube. Entire interview will be conducted. Then we will write that as a best practice. So there are countries who are that much transparent in the appointment process. And on the same part, we have India, where these collegium system is working as a black box. Okay? Even they will not tell you that why we are selecting this person. So that is the basic criticism. So what this will lead to, sir and ma'am, this will lead to 2 basic issues, and those are nothing but decrease in transparency and decrease in accountability. And then this will lead to the other major issues like uncle justice norm, nepotism, favoritism, dilution of the legislative, the strength of the parliament. If they are bringing anything, we are striking it off. So this will lead to the tussle between the judiciary and the legislature. Okay? And again this may lead to the dilution of trust from the citizens or by the citizens. Make sense? So this is the entire debate revolving around the appointment process. Please write it. Just show me the copy. How much space do we have? Okay, so you have to fix all of this. Then just a small part of it I will dictate here. Okay, this I will dictate. नीचे वाला इतना छोड़ देंगे आप. बाकी please write. इधर write the articles. Articles, Supreme Court, in bracket A.124. Articles in bracket you can write appointment. This you take in the bracket. Articles for appointment. Do not make the same structure. I mean, try to make it more compact if you can, or if you want to make the same, you make the same. Okay. This led to first judge's case. First judge's case. Please write in bracket. SP Gupta versus Union of India 1982. You should know this factual information as well. Recommendation, not binding. The word recommendation mentioned in the articles is not binding. Consultants doesn't mean concurrence. You can consult us, but whatever list we give, it's not necessary that you agree to it. In the first judge's case. Yes, online. Good points. Samrat Nagavanshi, good points here. सूरज वर्मा हिंदी की क्लास यूट्यूब पर. बेटा हिंदी का बैच वी हैव, राइट? इन द हिंदी मीडियम वी हैव द बैच ऑफ वज्र. Second judge's case, SC, that is Supreme Court, advocates on record. If you want to write the complete name, please write the complete name, but those who know, they can write the short form, A capital, O small, R capital. Advocates on Record Association versus Union of India 1993. Versus Union of India 1993. Recommendation is binding. Consultation means concurrence. Birth of collegium CJ +2. अच्छा, थर्ड जजेस केस से विल इतना लिख लिया. सेकंड जजेस तक. थर्ड जजेस केस, प्लीज राइट द नेम फ्रॉम हियर. थर्ड जजेस केस, प्लीज राइट KR नारायण केस. थर्ड जजेस केस KR नारायण केस 1998. KR नारायण, नारायण NARAYANAN, नारायणन केस. ठीक है. Again these two remains the same, but we'll just write CJ +4 and just mark a circle here that this is currently working, rest everything has stopped. Then we have fourth judge's case. Fourth judge's case. Again please write Supreme Court, same, the body is same now. Supreme Court, Association on Record, sorry, Advocates on Record Association, SC, Advocates on Record Association. Generally I remember this by SC Arora. ठीक है, वो अपना अपना लिंगो होता है, तो you can remember it anything. SCAORA. Supreme Court, Advocates on Record Association versus Union of India 2015. ठीक है. Please write NJAC null and void. NJAC null and void. Second point, please write Supreme Court brought M capital O small P capital MOP. Supreme Court brought, I will explain first, you write Supreme Court brought MOP in bracket Memorandum of Procedure. Memorandum of Procedure. So we saw that there are no transparency mechanism nahi hai. So what Supreme Court did, Supreme Court brought a casual, what is the guideline kind of setup. Whether it is being followed up, not followed up, nobody knows, because it is not getting done in public domain, right? But now there is some set of procedures which Supreme Court has listed on their website, known as MOP, Memorandum of Procedure, important from prelims point of view, not from mains point of view. Make sense? Okay. Chalo. Now understand. See, on the board now. Let's understand this NJC. So NJC, or National Judicial Appointment Commission, was brought in 2014 through the 99th Constitutional Amendment Act, which added the article 124A into the Constitution. This is there in your note, don't worry. And I just correct this if this is wrong. Understand what happened exactly in the NJC. NJC was the body which was comprising of 6 members, and any two, be it this two, or one from here, one from here, if they veto the selection process, the process will stop. United Nations wala veto, the process will stop. This says that the 3 members will be from the judiciary. One of them will be the CJI, and 2 will be other judges of Supreme Court, what is nominated by the CJI. CJI बताया कौन दो हैं आप? These 3. Rest 3 में there is union law minister which will be ex officio, होगा ही होगा, ex officio, no selection. Then 2 eminent people chosen by panel of 3 members, and those panel of 3 members is PM, CJI, and leader of opposition in Lok Sabha. First of all, we know about the issue of leader of opposition in Lok Sabha. There is no this single stand on the leader of opposition in Lok Sabha, which again is an issue. Then CJI sometimes may collude with PM and can hamper the entire process altogether. Okay. If any 2 of them, be it 1 plus 1, be it 2 from these people, if they vetoed the process, again it will halt. Next issue is executive interference in the process, where you are having the law minister in the appointment of the judiciary. So that itself is an issue. So if I see why the Supreme Court made it null and void, I will go to these points. That first of all, executive interference was there, as the law minister was ex officio member. Then veto power can lead to the blockades in the appointment. Entire judiciary can come to the halt if there are frequent blockades, like we see in the WTO. Have you followed the blockades in the WTO? Those are not, write it as the homework. Blockade in WTO. The WTO is a body, why it is standing blocked or almost non-functional till date. So it can lead to the blockades in the entire appointment process. Keep some like the recommendation is there, but it is getting blocked again and again. It is getting blocked. So what will happen? The vacancies will increase, and the entire judicial system will collapse. Then we have the eminent person. Exactly who could be appointed? Will you ask the PM? Will you ask the other person to get the appointment on the panel? What do you understand by the eminent people? The definition is not there in the NJC. So again, the Supreme Court was apprehensive that this can be misused, or again this can lead to the more executive interference. You define first whom you consider as the eminent people. Are these the lawyers with some experience? Are these the high court judges? Are these the MPs, MLAs, whom you will consider as the eminent people is the question mark. Then lack of judicial independence. The idea is the appointment process is going into the control, direct or indirect control of executives and the legislature, majorly executives. So this will hamper the judicial independence. Now what will happen? If the judicial appointment is in the hand of executives, the judiciary will try to favor the government more. Understand this. If the judiciary of the country is not independent, they know our appointment is in the hand of the government. Whatever are the cases related to government, they will be more obliged to the favor, or maybe in the favor of government. Agreed. So this will hamper the judicial Independence. Then we have the no guarantee of best selection. Again, you have not set any criteria, you are not told who should be the, set as the selected. What are the guidelines, what are the parameters, not defined again yet. The problem statement remains the same. It just earlier it was CGI plus 4, now you have 6 other members. Again, there is no timeline, no guideline, no rules, no transparency. The problem statement remains the same now. We have just replaced CGI plus 4 with CGI plus 2 plus 3. That is what we have done. And that plus 3 is nothing but the executives we are trying to impose. Make sense? So that is exactly why the Supreme Court striked it off, saying that it is against the basic structure doctrine, as it is hampering the separation of powers and the independence of the judiciary. Make sense? Now, why this should be done? Again, it will lead to more transparency, more accountability, because these people will not be working as a black box. They have to be accountable to the other 3. They will be telling them the reasons, they will be discussing the process, and they will be leading to the appointment. But again, those are nothing but the ideal case scenarios. Everything cannot work for long term in the ideal case scenario. Sometimes there will be tussle. There will be people who won't bend down in front of any of the interferences. Then what will happen? Okay? So all of them can improve the same issues: nepotism, favoritism, delays, accountability, transparency, and all those things. Okay? And then absolute independence of judiciary is threat. Right now, if you will see, if I want to fight any case, I am going to the judiciary. But if we will see this in the independence of judiciary, how the judiciary of this country is strong like anything. Even whatever legislature is doing, they are able to strike it off. Executive is doing, they are able to. Who is above them? Nothing. Because appointment is in their hand. Then this removal or the impeachment. Do you know the process? What is the process of the removal and impeachment? Huh? It is so damn complex that till date in the India's history, no judge has been impeached. It is so complex that till date, no judge has been impeached so far. So whatever independence they have in terms of the appointment, salaries, powers, or Article 142, or maybe in the what is the retirement stage, that any day can be misused. Because at the level of appointment, you have everything in control. At the level of removal, there has been no judge which has been impeached. The process is so complex. Okay? Now, if I see, so this we have covered. Done? हो गया ना ये? अब let's see the removal. Just see the process of removal now of the Supreme Court judge or maybe the High Court judge. See the process. What has to be done on the board? Just don't write anything यार, कहीं नहीं लिखा वो, बंद कर दो. ऐसे ढूंढ रहे हो कहीं मिल जाए. इधर देखो. On the board. So removal or impeachment of a Supreme Court or High Court judge. Again, this is important. Why? Because there was recent demand of the removal of the Chief Election Commissioner in the country, Mr. Gyanesh. Okay? So there was a demand by the maybe the opposition leader or maybe the other people, right? So the removal of the Chief Election Commissioner now is the same as the Supreme Court judge, and under the same act, which is nothing but the Judges Inquiry Act 1968. Same, exactly same. Okay? So what is the impeachment process of a Supreme Court judge? It goes like this. The step 1 is, first of all, there should be a motion passed in any house, and this motion should be admitted if at least 100 people in Lok Sabha or 50 people in Rajya Sabha agrees to it. This is step 1. This motion should be admitted by the presiding officer. Presiding officer, which is nothing but Speaker in case of Lok Sabha and VP in case of Rajya Sabha. So the presiding officer has 2 options now. Either he can say no or he can admit it. The moment presiding officer do not agree, be it whatever charge is there, be it how many people support the motion, if the presiding officer do not agree to it, the motion cannot move forward. Presiding officer has the absolute control on the motion. whether he wants to accept it or he don't want to accept it. So motion will go forward only and only if the presiding officer agrees to it. And if the presiding officer says that yes, we want to proceed, then the motion will go to the next level. That is nothing but the judges. Do not write, I will give you the time. Inquiry committee. This judges inquiry committee has 3 members, and those are nothing but CJI plus 2 people appointed by the CJI. This judges inquiry committee will submit a report. एक रिपोर्ट बनाएंगे, सबमिट करेंगे. The report again will either accept the charges or will reject the charges. Will accept the charges or reject the charges. Will say yes, the judge was wrong. Will say no, the charges are framed. The moment they say in the report itself, no, it is framed, it is wrongly framed, the judge do not contain any charges. If the inquiry says that, process stops there. Process will not move forward. In order to get a report, or what I can say, get the motion move forward, the reports should admit that there are the charges, or the charges are true. For example, recent Justice Verma, unke upar this committee was set up. Although he resigned, he is very smart. He don't want to bring his name in the history, so he resigned. Here, why I have to bring my name in the history to be the first judge of the country who was impeached? Let me resign. So he resigned. The committee admitted that he was involved in the corruption. Okay? The recent report came 2 days ago, if you might have followed the newspaper. So yes, if the admission is yes and the judge has not resigned yet, then it will move forward. Kya condition hai? Yes, and the judge has not resigned yet, then it will move forward. See the complexity. So if it is yes, it will move forward. It will be laid in the first house. It could be Lok Sabha if the motion is started in the Lok Sabha, or the Rajya Sabha, first house. The house should pass it with 2/3 of present and voting and 50% of total strength. It should be passed. If they reject, motion stops. It should be passed. Then it should be laid in the second house. Again the process remains the same, 2/3 of present and voting and 50% of total strength. What is the strength of the house? Then again it will go to president assent. And mind you, this president has again 2 options, yes and no. The judge will be only impeached if the president gives the assent. And if I say president here is not the discretionary power, it is the cabinet. Okay? So then this will lead to the impeachment. See the blockages. Generally in India's history, whenever these motions have been framed, the judges sometimes have resigned after this, or sometimes the judges have resigned before this, president ke assent se pehle. So till date in the country, we don't have any impeachment being done of the any Supreme Court or the High Court judges. Do I make sense? This we will write now. Show me the page. अच्छा, एक काम करते हैं, ये अपॉइंटमेंट के नीचे what we can do is ट्रांसफर्स के बाद देयर इज अ स्पेस ना, नीचे ये वाला स्पेस. यूज दिस स्पेस, गिव अ हेडिंग रिमूवल ऑफ सुप्रीम कोर्ट जज, और जस्ट गिव अ हेडिंग रिमूवल ऑफ जजेस. सुप्रीम कोर्ट और हाई कोर्ट, एनी जज, रिमूवल ऑफ जजेस. Write this in the flow wala format, like this only. Step 1, motion in any house. अच्छा, wait, in that removal of judges के bracket में you add, in bracket you write, this process is not mentioned in the constitution, this is mentioned in the Judges Inquiry Act. So just write the name of this act, Judges Inquiry Act 1968. The constitution says just this much, the judge will be impeached as per the provision made under the act of the parliament. The act which the parliament has made is Judges Inquiry Act 1968. Here I have explained you. Now even if there are writing issues or the handwriting issues, I think you should be able to understand, right? Presiding officer, yes or no? If he says yes, then only the motion will move forward. Then Judges Inquiry Committee will be there. 3 members होंगे, CJI plus 2. Judges Inquiry Committee, 3 members, CJI plus 2. They will submit a report. Report should admit it. Then only it will move forward. This is important for this year means. I mean, maybe the question can come in your year as well. UPSC has generally the habit of asking the same issue after 1 year. बोलेगा UPSC पहले भूल जाओ फिर पूछेंगे. Then first house, 2/3 of present in voting and 50% of total strength. Two-third of present in voting जो available है उसका 2/3 and 50% of total strength in both the houses. It should be passed. Are we done? So, now just above this एक चीज I skipped. Appointment में ना there is a space now. Just give a heading. Issues 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 in appointment system slash collegium slash collegium. Right at the level of judiciary. The points are same. I've explained you everything at the level of judiciary. First is favoritism or nepotism. or nepotism. Example, uncle judge syndrome. Right? Undermines meritocracy. Undermines meritocracy. Example, due to poor transparency. Poor transparency. Third, poor women representation. Poor women. Can anyone explain me this? Why poor representation out of collegium system? Collegium system से poor women representation कैसे हो रहा है? See what is happening in the collegium. In those five, they are all males. If they are all males, they will end up appointing the male members, and that is where this is leading to the historical biasness in the system itself. Then since the appointment ke level pe there are no females who are sitting on the table to appoint the other part, they will end up appointing the males themselves, and that is evident that so far in India's history only 4% of the Supreme Court judges have been women, and currently if when I'm talking right now, only 2 out of 38 judges are women. So the clear evidence of this is nothing but poor women representation in the judicial system. Again, the value addition remains the same. Example, 2 out of 38. This you can write. Then write legislature. Legislature. First point. Legislative inability. Legislative inability to fix the issues. So if they are doing any efforts to fix it, Supreme Court is tying it off. Example, struck down of NJC. And now second thing is, this collegium system is extra constitutional nature. In constitution there was no body like collegium system. Supreme Court interpreted it through the various cases, upgraded it, and then made it as a working mechanism. So when I say from the legislative point of view, this is extra constitutional nature, not mention the constitutional explicitly. Okay, please write collegium system as extra constitutional, semicolon, hampering extra constitutional, collegium system as extra constitutional, semicolon, hampering legitimacy of parliament. So what has happened in our country is people have empowered the parliament to make the laws and maybe the systems for the country, but this judiciary has made the system of their own, hence hampering the legitimacy of the parliament. Okay, then right, next, for the citizens what will the impact? Please write erosion of trust. Erosion of trust. Example, black box semicolon by second ARC. Okay. So since this is working as a black box, the people start losing trust on the judiciary. They are appointing whomsoever they want to the system. Example, black box, same value addition which you have done here by second ARC. By second ARC. Done. Chalo. Chalo. Again, look at the board. Look at the board. If we want to understand the cycle of judges, appointment we have done. We have done the collegium system. We have done the first judges case and all the judges cases. We have done the NJC as well. Okay. Either we have done the entire removal process. This we have done. Now, during the work, the first issue which they are facing is transfer of judges. And the second issue which we faced here out of collegium system is lower women representation. So during work process, these two topics we have to cover now, transfer of judges, and second is poor women in judiciary. So first let's start about transfer of judges. First you will understand, then you can read this from the document, it will not take much time. Just look at the board. Let's understand this, sir. Okay. Okay. Achha, will we talk about the transfer of Supreme Court judge? Does that make sense? Transfer of Supreme Court judge, does that make sense? No. We have a single Supreme Court only. Transfer means transfer from one state to another state. So whenever we talk about transfer of judges, we talk about High Court judges. Okay. And the article which deals with this is Article 222. Okay. Up. This means from one High Court to the another High Court. Done. Now in this we have to cover two important aspects. First of all, we have to see the need of the transfer. Not that important. Then we have to cover the basic issues which are coming in the transfer. Just look at the board. क्योंकि document तो आपको ही पढ़ना है. Look at the board. If I talk about why we even need the transfer of judges, how you will answer? Is it always politically motivated? The one of the aspect of transfer of judges could be, for example, in some of the states there are less number of judges. In some of the states there are high number of judges than the strength. Don't you think some of the High Court judges can be transferred from one state to another state? Second is to balance the the intellect level in the High Court. For example, let's say in some of the High Courts, either the strength is low or maybe the quality is not that apt. Experience, I will not use the word quality, I will say experience. Experience is not that apt in that High Court. So what we can do, we can take the High Court judges from the one Supreme Court, the experienced people we can transfer to that High Court which has the less experienced High Court judges. Make sense? What else? To prevent corruption. See, generally what happens, sir and ma'am, what happens whenever the judge stay in the district or maybe in the state, there is a nexus which is building up, the connects or the context which is building up. For example, if I am a big corporate, I know that judge settled my case, maybe backdoor through the connects or the contacts. What I will try to do, I will try to take my case always to the judge by some of the mechanism. So there will be a nexus which will in turn lead to the corruption in the judicial system. So the more the time the judge stay in that state, it leads to the connections and the corruptions. Generally, if the judge is corrupted, okay, so what we do? We do the transfer. What else? Saving of life. Sometimes what happens? Sometimes these judges, post delivering the verdict, get the life threats. That since you have not given the verdict in our favor, the gundas or the mafias will threat them. So what is in their favor is to transfer them to the safer state. Okay. Sometimes, generally, if the public opinion is not in their favor, if they have given the verdict which was not as per aligned with the public opinion, generally the judges are transferred. Okay. So that is the need of the transfer of the judges. If I brief you, the need could be to balance the merit, then save life if there is a threat, then break the nexus, and then prevent the corruption, and then transfer the judges if the public opinion is not in their favor. Sometimes these judges are forced to give the judgment which is not there in the public opinion. Let's say the public opinion was kill the rapist, but the judge never got the evidence against the rapist. The evidence was not appropriate, complete, but the public opinion was kill the rapist. So in all those circumstances, generally these again start getting a life threats. So need है ना, need के बाद issues. What are the issues? First we'll start from the technical issues, then we'll go to the general issues. What are the issues in the transfer? Understand this. Technical issues. See, for example, there is a case which generally has the bench of 3 judges, or maybe let me take a more strength, 5 judges. The case may the verdict which is yet to out, and the government is one of the party. Verdict is yet to be out, government is one of the party. Government knows that 3 judges are not in favor, 2 judges are in favor. What now the things can be politically arm twisted or motivated is government can transfer one of the judges and can bring the judge which is in the favor of the government. So now 2 will be against and 3 will be in favor of the government. So that is how sometimes these transfers are politically motivated in nature and being criticized. Sometimes, I mean, in the need we can add one more point just to penalize the judge for the wrong, what is the behavior and all those things. We can use the need. What else are the issues? What else are the issues? One technical issue we have seen. The other technical issue is the discontinuity in the justice delivery. See, the judge was hearing a case. Let's say my case is being heard by X judge. He got transferred. My case will be heard by now. Why? I have to explain everything again. The process may change, the things may change. So there will be discontinuity in the justice delivery system. And not only this, if you will see the depth of this issue, the depth of this issue goes into the fact that the accountability of the judges will start decreasing. If I have to deliver the judgment, I will be more accountable. I will hear it more, what I say, seriously. But if I know I can be transferred any point of time, I will be not that accountable or maybe not that serious with the cases. I will keep them on pending. When I will be transferred or when I will be retired, someone else will give the judgment. Okay? So those are the issues hovering around the transfers. So I have given you the brief, the gist on the transfer of judges ka issue. What you have to do is you have to open your handout and read this. Need and the issues. In the handout is very briefly given the need and the issues. Need nahi hai share handout mein. Write the need. Safety of life. Safety of life. Need. शायद need नहीं है ना handout में. First is safety of life. Second is break the nexus. Break the nexus. In bracket you write, just write whatever I am dictating. Break the nexus. In bracket you write, prevent corruption. Prevent corruption. Third point you write, in the public interest. In the public interest. Fourth point you write, import better talents. Import better talent. Import better talent. In bracket, remedy for inefficiencies. In bracket, remedy for inefficiency. Done. Issues में first is opaque collegium. See, this transfer under Article 222 is done by the same process. The same collegium recommends the transfer. So again, why the judge is being transferred? What is the reason is not brought into the public domain at all. No timeline, no guideline, no transparency, no accountability. So no clear parameters are there for the transfers. Then you have transfer of the dissenting judge. What I told you, 3:2 का था, 2:3 कर दिया. Dissenting judge is transferred. Then it impacts the due process of law. So the outcome should have been different, but now the outcome is different. Then it reduces judicial accountability. It reduces judicial accountability. I will not be much accountable for the case which I have been hearing. I will wait either for my retirement or I will wait for my transfers. Okay, for the serious cases. Then it impacts the independence. If you are transferring the judge will be in stress or maybe can bend down or can twist down. Here if I am being transferred, my family have to transfer with me. What about the education of my children and otherwise? Okay. So it impacts the independence. Then it impacts the promotions also. Maybe I was the most senior currently in the current high court. When I was transferred, I was no more the senior most. Okay. So I cannot become the chief justice of that high court anymore. Then political judicial nexus there and punishment postings are also there. Because sometimes these people are punished. Again, you can merge some points and at least you can frame 5 good and decent points out of them. Okay. Chalo. Next is women in judiciary. Women in judiciary. See, on the board. Right now, if I want you to explain the gravity of the issue, I will give you the few data points. The data point goes like this. If I talk about the Supreme Court, this we have already discussed. 2 out of 38 currently are female judges. And second data is only 4% judges out of total judges appointed to the Supreme Court have been female so far. Just 4%. Second data point goes like this. In High Court, till date, only 14 to 15% judges have been female. In district courts, around 30% judges are female. Can you see the issue, that the same issue which we see in the corporates of glass ceiling? That when we come to the promotion, the women are not promoted much or more. See the representation district judge, then lower in High Court, then lower in Supreme Court. And if I talk about lawyers, again in lawyers, we have the representation of around 15%. So this data you will write at the top. The top space which is empty, write the data. है आपके में data है? Okay, fine. So as of now, अच्छा, this is 38 now, ठीक है? And this is 12. I think this is correct in your notes, right? 12 and 38. Is it? Okay. Then only 14%, only 15% of the advocates. What extra you can write about the district court if it is not there in your notes? District court mein women representation is 30%. If it is not there, under the same head, edit. Now this we will use in essay writing or maybe sometimes an introduction. Okay, what are the case studies? First is first female Supreme Court Judge of India. In 1989 she was appointed. Understand now, after how many years of independence? Almost after how many years of 40 years, almost after 40 years of independence the country has the first female Supreme Court judge. And then we are talking about the women rights in India. Okay, the name was Justice Fatima Bibi. Then two current judges are Bibi Nagratna. She is supposed to become the first female CJI of India in September 2017, just for 36 days. That will be the duration of her. Only for 36 days she will become the CJI of India, right, as per her seniority. And right now there is one more Supreme Court judge. It is Mohana. What is the full form? What is the full name? B. Mohana. It is there in your notes. I have corrected, I have updated the notes. Notes are updated. Okay. So we have seen the current scenario, we have seen the case studies, everything. Now the idea again boils down to on the board. What do you have to cover extra in this now? First of all, we have to cover why is the current circumstances. And then we have to cover that if we fix it, what is the importance or need of more women in judiciary? Why I even need it? The first thing is why we have lower women representation in the judiciary. How we will decode it? How we will try to remember this? At least if you have to write 4 points in the exam hall, what should be the thought process? The thought process goes like this: there will be some issues which is from the demand side, and then there is some issues which is from the supply side. So from the demand side, the issues are from the judicial system wala side, and we have seen one of the issue which is nothing but dominance of males in collegium. And second issue is historical biasness. Understand this, right now in the country, even till date, the mindset is not that for the male counterpart the female will tell the verdict. So our society is patriarchal in mindset. They generally do not accept women as the decision maker. That is what we say as the patriarchal mindset, right? So that is something which is being percolated into the judicial system as well, that male counterpart or maybe the demand wala side mein people generally are not comfortable accepting women as the appropriate people to make the justice delivery for them. Make sense? Then we have supply demand wala side mein we can write about the infrastructure. So right now if I talk about the infrastructure of this court, we don't have the separate rooms for the female judges. They have to sit with the male judges. Then we don't have the separate toilets for the female judges. Again demotivating them. Either you can write it here or here, hardly it matters. In supply side, you can talk about the double work burden on the females of the family. And this profession is time consuming in nature. Okay, you have to be there, you have to give the time to become a judge. So there will be some issues at the level of demand level, and there will be some issues at the level of supply level. So demand side, opaque process, lack of women in collegium, biasness and promotions, no binding guidelines, male legitimacy leading to exclusion. Just merge these, make 2 points. है ना? You can merge them, make 2 points. I have given the gist. The gist is coming: collegium working as a black box, hired what I can say hijacked by the male counterpart. Hence they are not what I can say selecting women on the panel. First thing. Second is coming from the mindset, the societal mindset of being patriarchal in nature, where there is historical biasness in accepting women as a decision maker. Okay. Then you have supply side. Supply side में long working hours making as a drawback, then gender insensitive infrastructure is there, then social mindset is there, that women generally are not motivated to take this as a profession. है ना, the pink collar jobs and all those things in the society. ठीक है, so that is how you will see the why we need women in judiciary. ठीक है, समझ गए? आगे need क्या है on the board. If I say need, how you will think upon this? First of all, there will be the need for the justice, or maybe laws, or maybe the quality of the justice. What will happen? See, if you are having more women on the table, more women on the judicial system, or maybe in the justice delivery system, what will happen? This will bring the more what is the this contributions towards the other gender. Then this may bring the things balanced, or the justice delivery balanced. Not only this may lead to the gender sensitive laws in the country, or directives in the country. For example, the Vishaka guidelines, which we see as the She Act 2013 in the country, sexual harassment at workplace. The outcoming of those sexual harassment at workplace 2013 ka act is nothing but the Vishaka guidelines. Those guidelines were given by the female judge, Justice Sujata. Okay. So what will happen to the justice? Justice will become more gender sensitive, and it will become more balanced in nature, because you will have the perspective of the woman as well. Not only this, I will tell you the case. See, in one of the this High Court ka judgment, a rapist and a victim was there. The verdict was that the rapist, the victim was asked to tie the rakhi on the hand of this rapist. So this shows that if we are having only the male counterpart, this makes the justice delivery gender insensitive. Okay. Then second need will be from the what is the woman as victims. See, on the board, understand this now. For example, in some of the issues, women are not comfortable to disclose what happened with them in front of the male counterpart. So what is happening? For this reason, the woman refrain to go for the justice delivery system, that some male will be hearing to it, how we will be able to express what happened with us. Not that comfortable to express the issues or maybe the concerns with the male counterpart. So if we have more female judges on the bench, and the female judges are listening to those issues, then this will make those victims more comfortable not only to come out, report it, and in the process as well. Okay. Now again there will be the fillers, the other point, for example, increase of trust in the justice delivery, more participation, etc, etc. Okay. That is how we see this topic, the need of women in justice delivery. The need is in judgments, it will make it inclusive, both male and female will be contributing, more diverse composition will be there. For example, Vishaka guideline in 1997 was given by Justice Sujata Manohar. Then gender sensitive judgments, for example, compromise weddings, rakhi will be avoided. Okay, I give you the example. Then victims ke level pe, help women come out and report the crimes, will increase reporting, public trust will increase, judicial legitimacy will increase. These are nothing but the fillers. Okay. Then you have the social, that remove ill belief of women incapability. When women will come out, they will give the pronouncements, the social mindset that women are not capable of, we should not be listening to them, will be seeing a setback. Okay. Remove ill belief of women incapability. Just see your notes now. Then we have the way forward. Way forward, there is a very important committee or the commission, which is, just make a box over this, K.K. Venugopal. So Attorney General K.K. Venugopal suggestions. So sensitization of judges, improve representation, and do the data collection so that we can push it more aggressively. Then we have fixed quotas for the women in justice delivery as well. Do it like local bodies, or maybe whatever you have made right now, Nari Shakti Adhiniyam, Lok Sabha and all those things. Okay? So make a fixed quota. Then transparent appointments. This is correct in your notes. This is transparent. So work on the collegium system, because the basic root is lying there. The collegium system is not transparent, hijacked by the male counterpart. The root is lying there. The moment you make it more transparent, you hear the counter arguments of the women. Take their interviews in public. You will be appointing them. Then you have incentives. Please write here. Make everyone write. Incentives for women. Incentives for women to be part of judicial system. To be part of judicial system. ठीक है. Now what we have done, if I again come to this slide, we have covered this process. ठीक है. Now understand one thing. When I talk about the work being done by the judges, it is important for us to understand that now there are two major things on which we have to focus. थोड़ा काम हो जाओ, सुनो मेरी बात, because now we are changing the topic or the direction of the discussion. ठीक है. This has been completed, sorted. हो गया. अच्छा, take 1 minute, just skim through. देख लो क्या क्या किया अभी. Whatever you have done, just skim through. Just skim through. Headings देखिए, थोड़ा validations, keywords. Are you comfortable so far? बेटा स्किम थ्रू. यहाँ क्या देख रहे हो? ड्राइंग देख रहे हो क्या? अपना रिवाइज करो ना यार. चलो ऑन द बोर्ड नाउ. On the board, everyone, please. Now we are starting a new dimension altogether. See, if I want my judges to work with the right mechanism to impart the justice which is fair and which is not suppressed or influenced by any pressure, what I have to ensure? I have to ensure the independence, so that whatever salary they are getting is not influencing their decision, their transfers is not influencing their decision, their removals is not influencing their decision, their retirement is not influencing their decisions, the working condition, the work domain, or maybe the judicial enforcement is not hampering their independence. This is important so that my justice is enforceable and of quality nature. Okay. Now understand, whenever they are working independently, we will see a mechanism of judicial review, and sometimes we will see the two other mechanisms parallel to judicial review. Parallel, these are not subsequent, these are parallel to judicial review. I will explain you very beautifully all three of them, just don't worry, allow me some time. Judicial activism and judicial overreach. If it is judicial activism, it is win-win for everyone. But if the independence of the judges is misused by them, then it may sometimes lead to judicial overreach. So it is important on our part that they are not using their independence wrongly. For that, it is important that we see the topic of judicial accountability as well. Okay. What we will do is, we will start with the topic which is judicial independence. Judicial independence. And we will start first of all the need for judicial independence. Close your copy, take out a rough page, because now we are seeing a different framework, a very important framework. This is a framework 3, 2 I have discussed. पहले page पे first and 2 frameworks I have discussed. This is a third framework. Judicial independence. I am saying, what is the need of judicial independence? What do you think is the need of judicial independence? Why we need judicial independence? Please tell me. Sorry? Biasness is fine. So can I say biasness and all those things is nothing but if I want to abide by rule of law, if the court has to follow, the justice delivery has to follow the rule of law, the system should be independent. Okay? Otherwise the biasness will come and the justice will be compromised. What else? Checks and balances on what? ठीक है, sorry, ठीक है, check executive and legislative authoritarianism. ठीक है, can I write this as to protect? See what he has said and what I am writing. What I am trying to do is, I am trying to make a framework which you can use in other topics as well. I am just changing the word and I am making those words very general, which will start your keyword. To protect individual rights and to protect societal rights. When you say that you don't want the system to be authoritative, that means you are either protecting the individual rights or you are protecting the societal rights. Hai na? What else? Uphold the constitution values. So can I write to uphold the constitution? Whatever are the provisions, the articles, the parts, the schedules and the mechanisms provided in the constitution, it is very important the Supreme Court acts as a guardian of the constitution. So in order to act as the guardian of the constitution, it is important for the Supreme Court to act independently, right? What else? federal values. So if we want to uphold the federal structure, it's very important that the Supreme Court is independent. Okay? The laws of the rights of the state, the right of the center, the right of the local bodies as well. You want the independent system to work. What else? Separation of power. Very good. To ensure the separation of power, whatever is wrong shall be termed as wrong, shall be struck down like NJC. We need independent body which is not suppressed or dominated by the executive or legislature. Otherwise the entire system will collapse like anything. Okay? And lastly is to protect the to uphold the principle of natural. See, these are nothing but the keywords, pillars hai. I will not say them as the pillars, but a keyword, a framework. Either the Supreme Court will protect the individual right or the societal right, or maybe the laws, the rule of law, whether the laws are implemented correctly or not, or else it will uphold the constitution, or else it will uphold the federal structure, or else the separation of power, or else the principle of natural justice. And this is nothing but the exactly the need of independence of judiciary. Okay? So this I am dictating, you please write one by one. You have the space there. Okay? The space में सिर्फ इतना ही लिखना है, तो you can use it very wisely, it's fine. Or what you can do one thing, you divide the space into two equal half, central line ऐसी बनाइए, divide whatever is the space, two equal half I am saying. ठीक है? On the right hand side give a heading, need. Need or importance. First point you write, uphold the constitution. Uphold the constitution. In the handout there is a space below independence of judiciary. If that space you divide into two half, मैं दिखा देता हूँ बेटा देना. This space shall be divided into two half. Then you have to write on the right hand side, uphold the constitution. Example, just write a keyword guardian. Supreme Court is guardian of the constitution. Then write one more example, basic structure doctrine. Uphold the constitution मतलब क्या? Supreme Court is the guardian. Second is basic structure doctrine. Second thing is wait. Second thing is protect federal structure. Third is ensure separation of power. Separation of power is under article. Example, evaluate article 50. You will write complete. Article 50. Fourth, you write checks and balances. This we missed. Checks and balances किसके ऊपर लगाएगा? Checks and balances on legislature and mark it 1 star. Checks and balances, a very important role of the independence of judiciary, that you have to keep a check on the legislature and executive. Then you write fifth, individual rights. If your handwriting is big and it's not coming into the one side, you use the second side. It's fine. By any chance. Okay? You can use the second side. Whatever is the next topic, we will write it somewhere else. Individual rights. Please write. Example. Right to privacy. Right to privacy. Can you write the case now? KS Puttaswamy case. Please write. KS Puttaswamy case. Then write next. Societal rights. Example. Ban on triple talaq. Ban on triple talaq. Then you write uphold rule of law. Example. Release of this case we will discuss in detail shortly in PILs. You just write release of under trial. Hussain Ara Khatun case, right? So we will discuss this case, Hussain Ara Khatun case. I will make you write there. Just write here release of under trials. Then you write it. Judicial review. Semicolon. Uphold principles of semicolon. Uphold principles of natural justice. Uphold principles of natural justice. We will review this and this. I will discuss. ठीक है अभी 90 right. Uphold public trust on judiciary. Uphold public trust on judiciary. ठीक है. So see, whatever you have done right now can be used in various topics. Photo independence. I am saying the importance of judiciary. What do you like? Same thing. I am saying the importance of judicial review. What do you like? Same thing. So whatever you have done right now is a framework which will help you to generate not only the keywords but the quality points in your answers. Okay. So very important keyword of what again the very important framework of justice, the judicial independence, even activism, and even this will be using in the different topics. For example, now on the board, if I ask you what is the importance of PIL, public interest litigation, most of the points will be similar. मेरी बात समझ रहे हो? है ना? ठीक है. If I ask you what is the importance of Article 142, those who know Article 142, Article 142 says that Supreme Court has the power to do complete justice in any case. So what is the importance of this? Same. So right now you have the further examples framework for various topics from now. Okay. Some of the top points I will be picking up from this framework only. Now, before I move ahead, a next framework which I wanted to see Look at the board. Is this in your handout? Wait. No. Look at the board. पहले देखेंगे फिर I will give you the time. When I talk about any law in the country, apart from judiciary, will have two important players, and those two important players are nothing but the legislature, the people who will be making the law, and then the executives, the people who will be implementing the law in the country. When I talk about this legislature, when they are making any law, they may have three conditions. First condition is the law is just in nature. Second condition is the law is unjust in nature. What is the third condition? For any area, about the role of legislature regarding that area in the law making, या तो just है या unjust है. What is the third area? Third area is law is not there. Issue is there, but the law is not there. That is, I am having a vacuum. Are हाँ या ना? That is how the things issue works. Again, this is the framework. This will open your head how you have to think on the topics. Either I have the law which is just, I have a law which is unjust, or I don't even have a law to deal with the issue. Okay? For example, right now if I talk about cyber security, we don't have any dedicated law in the country. Hey, nahi. Whatever we are dealing through the IT Act. So either just, unjust, or vacuum. Now, what judiciary will do in this case? If you are going to judiciary in this case, what judiciary will do in this case? You went to the court. You just said, please look at this law which the legislature brought. Just look at this law. What judiciary will do? Review. And what we say this as judicial review. See, I am trying to impart the very basic essence of what is judicial review, judicial activism, and judicial overreach. Just understand this. Okay? Otherwise, kitna bhi padh lena net, you will stay confused. On the board. If law is just or unjust, it can be reviewed. If it is just, it will be passed. For example, Aadhaar. If it is unjust, it will be struck down. For example, now that is the interpretation of the judiciary. We don't even go into it. Whether the Aadhaar was money will or not, just leave it. It was just accepted under the judicial review. Unjust, not accepted, like NJSC. यही दो केस होंगे. Review हो गया. Act is reviewed, law is reviewed. Right? In vacuum, what will be the two cases? Now this is important. Understand this. If there is no law to deal with the issues in the country, there are two conditions. First of the condition is, I will ask a question upon the emergency, or the more appropriate word is urgency. Do we need the law? Is it urgent? There may be again two cases. Yes, it is urgent, but the parliament is not listening to it. The parliament is not sitting for it, but it is urgent. It is urgent, but the parliament is not listening to it. They are not considering it as a priority. Second thing is, it is not urgent. We don't need it right now, right away for the country. Not urgent. If the judiciary has brought the law for any urgent issue on which we don't have the law, this is judicial activism. But if the judiciary is intervening to bring a law for which, let's say, there is no urgency in the country of whatsoever nature, this is judicial overreach. Make sense? Are we clear until now? Let's see the Same framework for the executives. How it works? For the executives, what they are doing is they're implementing the law. So there will be two things now. They're not making the law, they're just implementing the law. There are two things now. Either there is action or there is inaction. Either they are taking the action on the given law or they are not taking any action on the given law. Okay. If they are taking action, again there will be two cases. It is just and it is unjust. You can go to the judiciary for their actions. If it is just, it can be reviewed and the judiciary will say okay. If it is unjust, judiciary will say not okay. For example, this 2G coal scam or maybe whatever the scam has been done in the country, brought to the judiciary. That was nothing but the executive action. That executive action was reviewed by the judiciary. Again a part or component of review. Although you don't term it judicial review, we say that as a verdict. But again the action was reviewed. And now again there is a story. 2017 it got reversed. No one was acquitted, but let's not go into it. Okay? This inaction. If the executive is not taking any action on it, okay. Again there are two things. We'll go to the urgency. Whether there is urgency in the country or not for that inaction. Again it will be divided into two. Yes, this is urgent. No, this is not urgent. For example, recently you write release of under trials. What happened in the country, beta? There were some people lodged into the jail, and the the time period which they served in the jail was way more than the maximum punishment they would get even if they are convicted. So what Supreme Court did, what the court did, they intervened and they released a directive that if the person has served more than 50% of the maximum conviction time period, please release them, release these under trials. Why? Because the conviction rate in the country is 50%. That means 50% of them, statistically speaking, are innocent, and you lost them into the jail. Okay. So that is another thing. So I consider that as urgent issue which was settled by the judiciary through the intervention. So if it is urgent, it is again judicial activism. And if it is not urgent in the country, then it is judicial overreach. I will give you the example of this. So I mean, आज से 1 साल 2 साल पहले या 3 साल पहले during the COVID, the judiciary gave the verdict of mandatory playing of national anthem in the cinema halls. How many of you have witnessed that? How many of you stand, in the cinema hall? So in the cinema halls, judiciary said there was a verdict that now the national anthem before the movie is mandatory in the cinema halls. Is it urgent? Can you imbibe the sense of patriotism through this action? Can you do that? I mean, necessarily not. There's something which do not work well with the people to force them for the patriotism. So I believe that was not urgent to be done by the judiciary. Now there are some green areas in this sometimes. For example, there was an issue in the country where the Supreme Court banned the liquor on the highways. How many of you followed that? Banning the liquor on the highways. So there was again, the lot of the criticism of that particular verdict. The rationality was of Supreme Court that whenever people are moving on the highways, they are drinking and driving, and this is leading to increased road accidents in the country. But the idea is, the practicality is, when they are traveling on the road, they are carrying their own stuff. They do not waste the time of standing on the shop, purchasing it, and then driving the car further. They घर से लेके निकलते हैं. That is how the things work mostly. And do you think it is complex for them to put it on the Google map and go 500 meters inside and bring that bottle? Is it complex now in the current scenarios with the technology whatever has been deployed in the country. So what if they went, the norm was 500 meter के around नहीं होना चाहिए. So let's say that the 600 meter there is a shop or the ठेका, they will go to that shop, they will bring and they will run on the highway again. But ultimately what you did is you try to destroy the economic ecosystem of that liquor wala thing. Okay? The shops, the employment, and there all those things was never being heard of. So again, I find some of you may find this as a judicial activism, but some of you may find this as a judicial overreach. Let the executive do it. Ultimately, whatever you have done may not bring any result. Okay? People know how well they have to bypass the thing, right? So this is the entire story. That is how you see the country, the legislature, executive, and their interference with the judiciary in whatever actions or the laws they are bringing on the table. Make sense? This is the framework which I wanted you to write on the right hand side, but if you don't have the space, just write it wherever you have the space. On the previous pages, if you have the space, you write it. Huh, sir? See, again, NJAC is not judicial overreach if you will ask me. I will give you the reason, because there will be the blockades, there will be the political interference, the independence will be compromised, the structure should be much more better, the clarity should be there, the transparency should be there. If they are bringing the NJAC, we'll talk about the NJAC of the UK, or maybe the bodies of the US. What they are doing in US especially, they are keeping the appointment in the public domain, and the people who are taking the interview, they are not from the executive wala front or the legislative wala front. They all are the judicial experts or the eminent personalities who are taking the interviews in the public domain. So we can make it much more better. The idea is right. The idea is that we have to make a judicial appointment commission, but the composition is something which is hampering the body. You can write the example of guidelines in bulldozer justice. अच्छा, लिखने से पहले समझ लो what happened recently. There was a trend in the states like UP. What they used to do for any issue, they used to go with the bulldozer and they used to rain the house of the person. What is the issue here? The issue here is the executives are breaching their domain. ये action नहीं है, inaction नहीं है, this is the over action, that you are either bypassing the law or you are overreaching the law. You are taking the bulldozer for, let's say, whatever crime may be justified also, but what is the issue here? Anyone? Demolishing the house, you are punishing the family who contains the innocent people of that family, who might not be involved in that crime or maybe the issue, even if it has been done. So judiciary or this what I say, this judiciary brought the guidelines. They said the demolition is fine, but that should be followed as per the MCD guidelines or whatever the municipality guidelines is there. If there is any breach, if the shop is extended, then the what is on the road or maybe built on the road, you demolish it. But you cannot demolish the lawfully constructed properties without the intervention of the required authorities. ठीक है? So the guidelines were there कि publish करना पड़ेगा, पहले बताना पड़ेगा, consult होना चाहिए, DM का approval and all those things. Published by the judiciary to do this, and I consider that as a judicial activism, not the overreach. Done? Shall I move ahead? यस टेल मी. हाँ कौन है, हाथ उठाओ पहले. हाँ आई एम कमिंग टू द एग्जाम्पल, जस्ट डोंट वरी, यू जस्ट राइट इट. डन. हाँ हाँ I'm coming to the example, just don't worry, I have to start the topic. As of now, this is the framework. I've not started the topic yet. We are yet to start the topic. This is the framework. Done. चलो. Are you all comfortable so far? Online comfortable? ठीक है, आगे बढ़े. चलो. Now we will start the topic of judicial activism and overreach, both of them. ठीक है. अच्छा, we missed one thing यार. We missed the provisions of the independence. Just show me this. Tools to protect independence. अच्छा मिस नहीं है, इसके बाद ही आना है. ठीक है. That what are the provisions available in the constitution to ensure the independence of the judiciary. So if I talk about the provisions, we'll start from the appointment first. The mode of appointment, collegium system, ensuring their independence. Then we will see their service condition, the salary. First of all, the salary is charged upon consolidated fund of India. It is not voted, it is charged upon, that it cannot be changed. Second is, there is in the salary only, it is written here, financial independence. Salaries and pensions cannot be curtailed. First is charged upon. Second, it cannot be decreased or curtailed as well. Then if I talk about their own staff, they have the freedom to appoint their own staff as well. Now when they're working, what are the independence tools? First is contempt of court. If you will see, if you will defame, if the orders are not being heard, the contempt of court provision is available with them. Not only that, when they are working, whatever is their result or the outcome of the verdict, that cannot be discussed in the parliament. Okay? So conduct of judges cannot be discussed in the parliament. This avoids public pressure on the judges. Done. Then again we'll come to the last, which is nothing but the mode of removal or the retirement. Mode of removal में there is special majority. We saw, देखा था अभी, 2/3 present in waiting and 50% of the strength. And second is post retirement, that they cannot serve as the ban on practice. It is, what is the ban upon? Write it as a homework, please. I want you to have the clarity. Is it the ban on becoming the lawyer? Is it a ban on becoming the judge again? Lawyer in the same court. They cannot practice, but they can become the judge post retirement, maybe in the tribunals, or maybe as the, you might have heard about these this additional judges. Suna hai? So just those who don't know, write it as a homework. Just read it once, then let's move forward. sorry, no, that is also the independence. ठीक है, चलो. Now just can you read the few points given in your document? Show me the beta. The points are judicial review. What is the need of, or why we are like what is the importance of judicial review? These points. These points. Again, this is derived from the same framework. ऊपर वाली framework से आ रहा है. Uphold rule of law, uphold federal structure, safeguard constitution, checks and balances, ensure separation of power. Judicial review. ठीक है? From the same framework, whatever you have done, ऊपर उधर से ही the points are coming. What you can do extra is you can add the value additions. For example, individual rights may protect fundamental rights like right to privacy. Just do the value addition. Societal में personal laws like Sabrimala temple entry का there was an issue. For those who have not followed, just write it somewhere in the homework. Sabrimala temple entry issue. Sabrimala. Then triple talaq. This we have written ऊपर वाले framework में. Then uphold federal structure. SR Mumbai versus Union of India. Misuse of Article 356. Promulgation. है ना? Sorry, this precedent rule. Then safeguard constitution. Minerva Mill case, which curtailed unlimited amending powers to the parliament. Safeguard constitution like Article 13 or maybe basic structure or maybe act as a guardian of the constitution. So Minerva Mill case 1980 curtailed unlimited amending power. Done. Now the next page. Judicial activism and overreach. Just read few examples of all of them. See, there may be sometimes a gray area on which you may not agree with me or maybe the examples written. Okay, it's fine. You can shift that to the gray areas. For example, highway liquor ban, censorship of Jolly LLB movie, right? So this movie was censored by the judges. Here you are showing us in the wrong limelight. So these two could be in the gray area. This could be activism now. This could be overreach now. Okay. Overreach if you are thinking from the aspect that it is hampering the right to express. Okay. Just see these cases. Select any 3 or 4, just 3 or 4 and use them as the examples in your answers. Any 3 or 4, do not keep all of them. You can write to add, please. See this case now. On the board, see this case. See, these cases will be used in the essay also, will use in ethics also. Okay, that is how the system works, the entire preparation system, right? The case is the Allahabad High Court gave the verdict that child of a bureaucrat in UP should be enrolled only in the government schools. The basic rationality given was or assumed was that if the bureaucrat children are studying in the government schools, they will be compelled to improve the quality of the public schools, which then at large will improve the education system of the entire state. That was the rationality given. Now I have written this in the overreach. You tell me why I have written this in the overreaching. What is the issue, basic issue in this? Sorry. Yeah, see, dictation is why someone cannot be dictated. Dictation is not the issue here. Fundamental rights of whom, and what fundamental right exactly? There are two important stakeholders. First stakeholder is the parent, and the second most important stakeholder, more important than the parent, is the child. It is not about the education of the parent whom you have dictated. You have told the child to follow the school because of the profession of his father. Here the rights which are being compromised are of the child who have not been asked for. उससे नहीं पूछा ना आपने कहाँ पढ़ना है. So the right of the child are being compromised. That is the first issue here. Second is individual rights, privacy rights, or maybe the right to choice of that father or the parent, or maybe the mother. They have their individual rights, the right to choice wherever they want to send their child. But just because of their profession, you are dictating them to send their child into the public schools is an issue here. Ethical perspectives, so there are issues, right? There will be some pros also, cons also for generally most of the issues, है ना? ठीक है? Write a homework somewhere now. Homework is, I want you to write 5 prominent MC Mehta cases. 5 prominent MC Mehta cases and 5 other environmental related pronouncements. Environment related pronouncements. Sorry. Environment related pronouncement. Okay. For example, let's say a river being declared as a living entity. I need those pronouncements, 5 of them. Either you Google or you do the chat GPT. Just do not write as it is. Understand the entire issue and then write it. Okay, this is the homework. Because in polity, if there is a question from the environment and related to judiciary or maybe the governance, these 10 cases will act as a fodder for you. You will write the complete answer, because then again everything is rest is filler. Okay. So next is advantages of judicial activism. See now on the board. On the board. What is the advantage of judicial activism? How you will think on the board, everyone, please. How you will think? Either the advantages will come from the first framework or the advantages will come from the second framework. Either you will write about it will uphold rule of law, it will protect individual rights, it will protect societal rights, that will lead to the this prevalence of natural justice, or else you will write it will prevent of misuse of power by the executives and executive inaction, legislative vacuum. You are ready with the answer? See this, all the points are same. That is how the things work exactly in the mains. That is how and a beautiful answer you will write if you have those frameworks ready. Just see the points. See, avoids misuse of power by the legislature or parliament, like promulgation of ordinances as cited in the Krishna Kumar case. All these cases we will see separately in the important judgments class as well. So the Krishna Kumar case mein the Supreme Court said that it is non-constitutional nature if you are again and again passing the ordinances and bypassing the maybe the state legislature or the parliament. Okay, Krishna Kumar case, a very famous case in the India's history. Then substitute weak governance. Again, this is either it could be legislative vacuum or it could be executive inaction, or the expedites legislation. Ban on 10-year-old diesel vehicles in Delhi. Check on authoritarian tendency of the government. Then fill constitutional voids, or it uphold, these are the pillars, so we can ignore. Uphold the right of citizens, that is the right of individuals. You can write here the right of privacy as an example if you don't want to duplicate the examples. Okay. Then social justice, to uphold the right of society. You can write here the triple talaq, Sabarimala, and maybe this Vishaka guideline. All of them perfectly fits as the example of the value additions. Okay. Then This is something which is additional now. See, understand this now. For humans, people are visiting the court. But what about those who cannot speak and go to court for themselves? Be it flora or fauna. They cannot move, they cannot go to court, they cannot file a litigation. So in order to ensure that their rights are upheld under the principle of natural justice, again, that is the importance of judicial activism. And that is where I asked you to write the MC Mehta cases. The MC Mehta, famous environmental activist, will find a very famous cases. For example, closure of the polluting industries within the mainland of Delhi, pushing the industries away from the Taj trapezium zone. Then Ganga pollution pe you will find the case of MC Mehta. Then Delhi mein vehicular emissions pe you will find a case of MC Mehta. Just read about 5 or 6 MC Mehta cases. Then Bhopal gas mein the compensation to the victims was the outcome of MC Mehta case. Okay? So whatever are the cases, just go home, read about the MC Mehta cases. Either you do the Google or use the AI. Okay? Both of them will work, but thoda 10-15 minutes dena. Give them 15 minutes, understand all the issues. Don't go comprehensive. Go selective, but understand that issue completely. Okay? 5 MC Mehta and 5 other environmental pronouncements. Done. So nothing different. This is framework 1, this is framework 2. We are done. Just add the environmental protection MC Mehta. Easy. Okay? Then let's say disadvantage of the judicial overreach. So for activism, will there be any advantage, disadvantage? Yes, if it becomes the overreach. So for overreach, what are the disadvantages? Look at the board. How you will think upon it? How you will think upon it? First of all, you will think upon the legislative line. What is happening now? Judicial. See, understand this. This is a very deep point, which should be the very first point in our answer. That right now, since the people have elected the legislature or the politicians, they have elected them. They hold the right to make the laws for the country. But right now, if the judiciary is taking the law making powers in its hand, or maybe guiding the executives for the actions, then what is happening ultimately, that they are having the powers which are extra constitutional in nature. They don't have the law making power, but now the law making power is going in their hand. They can give the directives to the executives and the legislature as well. What this will lead to in the long term? This will lead to in the long term decrease in legitimacy of the legislature and the executive, and which in long term will decrease the people's trust on the legislative and the executive. क्या होगा फिर? सोच के देखो. People don't have the trust on the legislature and executive. The people will start running towards the judiciary for everything. Ban stray dogs in Delhi, they will go to judiciary. Ban firecrackers, they will go to judiciary. They will stop going to the legislature, and they will ask everything what has to be done in the country from the judiciary. Hai na? There will be repercussions. Okay? Lawmaking is going into the judiciary. This will decrease the legitimacy. If the legitimacy is decreased, people will start going to the judiciary for everything. And ultimately, that is what happened during Operation Sindoor. What happened? What happened? People were very frustrated that in the Operation Sindoor, the India is not capturing the this Pakistan occupied Kashmir. So in news channel generally it was highlighted, although there was different news. Hua Pakistan par kabja, hua Karachi pe kabja. You will see the news channel doing this, right? But the public sentiments in the country was that through this, what we can do is we can bring POK to India. Okay, we will acquire all of, we'll send our army, our people, and we'll fans, and we'll do this through this process. Now whenever this talks start happening, people were frustrated. They were like, "Arey, why we are not taking POK? This is the right time, this is the right opportunity to get the POK. Take it from them. Okay, we have overpowered them. Le lo unse. Ab the government is tackling the issue. People are unhappy. What they did? They went to the Supreme Court and High Court. Order the government that we need POK. Order the government to file the missiles on the Pakistan. Arey, why the judiciary will do that? So that is how the people start having the perception of the judiciary. Okay? Chaliye. So what we have done so far is this. Article 142, just write at the top. It's a homework for you. I've given the entire complete information. Just write the homework. I'm discussing it. Break I will give after 15 or 20 minutes. Just pardon me for the same. Okay? Otherwise the topics will not be in sync. I have to complete the judicial accountability at any cost. Okay? Chalo. Just allow me 20 minutes. I will finish. Article 142. What this says? This on the board sun lo. Just listen to me. Then you will be able to read it. This is generally given as a homework only for the self reading. What is Article 142 exactly? Article 142 says that the Supreme Court has the power to do the complete justice in any case, even if the verdict is pending, even if the verdict is delivered. So the Supreme Court has the power to do the complete justice in any case is the statement of Article 142. And if you will see this is one of the tools of independence of judiciary as well. If it is not mentioned, you can mention it there. Independence of judiciary tools. Article 142 is one of the two. See, benefit we know. Benefit we know. What will the benefit of this? Rule of law, individual rights, societal rights, separation of power and all those things. आ गया? कोई तकलीफ तो नहीं है अभी? But if I ask you what is the challenges or the issues of this, understand this now. That since this is giving a blank check in the hands of judiciary, this makes it prone to misuse. It's a blank check, complete justice in any case, blank check. So this makes it prone to misuse. So that is the issue in this case. And what has happened in the past, the judiciary sometimes have ended up misusing it. For example, in Tamil Nadu, the governor was not giving the assent to 10 of the bills of the Tamil Nadu Assembly. The governor was not giving the assent, be it anything, politically motivated, etc., be it anything. The government of Tamil Nadu went to the court. They went to the court. The court listened to the entire issue. And then the court delivered the verdict with a 3-bench judge that the bill, listen to this, has this been covered by Amritan sir? The bill deemed to be passed without even the assent of governor or the president. And the very first time in India's history, the bill passed, although this has been upholded now, Supreme Court, after the intervention of the government, Supreme Court halted it. Give the verdict ki jo hua galat hua, all these things. That's a different story. Maybe the sir will deal with this in the federalism. ठीक है? Federalism topic हो गया आपका? नहीं हुआ? So we are having an extra class, है ना? Positively, what we are thinking is we will shift the ethics to one. What is the maybe Thursday ko hai to Monday ko we will shift out. We'll see. We'll tell you the entire schedule. We'll keep the Polity ka extra class पहले, so that we are completing everything at one go. ठीक है? We'll complete, then we'll move ahead to the next subject, है ना? चलो. So you will have the extra class soon in the next week of the Polity. Whatever is left from my section, for example, I deal maybe 1 hour or 2 hours का bodies, right? Some of the important bodies I deal in the extra class only. Bodies का section आज नहीं होगा. And some part of local bodies also, maybe cooperatives and all these things I deal in the extra class only. So I will take some section of mine in 2 to 3 hours. Rest Amritan sir will take, and we'll take an extra class on Polity. There is the announcement. We will deal that in the VAJRA channel as well. In that it will be covered. So what happened exactly? That the court ended up misusing the Article 142 by bypassing the governor and the president. Okay. So those are the issues. Now again, it is written here. Then there are some benefits also. The positive cases, for example, dissolve the complete divorce cases through the Article 142. See, the marriage laws in the countries can never be complete. Why? Because people can fight on any issue, and you cannot write all the issues in the act. Arey yaar, maan lo, you have to give the divorce. There will be some provision that this is on this we can give the divorce. But again, now there are new issues on which they want the divorce. So the laws cannot be complete. So what these courts are doing is these courts are using the Article 142 to resolve divorce cases. Then release of under trial prisoner the Husainara Khatun, use of Article 142. Compensation to Bhopal Gas MC Mehta case is again Article 142. The 2G, the revoke 2G scam was again done under Article 142. Then we have Supreme Court granted permanent commission to women officers in Indian Army. So earlier they were not having the permanent commission. Those who have not followed these issues, I want you to follow two issues. First is permanent commission to women. Write it somewhere in the homework. Second is women in combat roles. Permanent commission to women. And second is women in combat roles. Please यार, whatever homework I am giving, do this. I request you. ठीक है? आप मेरे homeworks को don't take it lightly, है ना? Whatever homeworks I am giving, make a list. Please do go home. Hardly it will take 3 hours. You will complete. I can ensure the coverage. You have to ensure the completion. ठीक है? So these permanent commission to women, comma, combat roles to women. A woman in combat roles. See, generally na, the women were not used to be allowed in the combat roles in India. Why? Because if they will be captured by the enemy, they can be mishandled, है ना? And then they can act as a negotiation trophy. Nevertheless, let's go through these two issues. Then again, there will be some benefits. The benefits will be those two frameworks only. Just you read this. The frameworks will be same. Either you fill the existing gaps, or maybe this protect vulnerable, uphold citizen rights, individual rights, societal rights, rule of law, and all those things. So those two frameworks will give you the content for the benefits. Done. Then you have the challenges. Challenges coming from the blanket check, that there is no limit on the powers in any case. So what this is leading to? Possibility of misuse, poor accountability, then again separation of powers, because this can lead to judicial overreach. Okay? And undermine rule of law as well. There may be the law, but the judiciary can bypass the laws as well under Article 142. Law hai, but then also the verdict as per under Article 142 can be different. That is the power of judicial board in the Article 142. It can bypass the law. Understood? Then inconsistency in the legal system. So laws are there, but judiciary is going maybe along with the law with their own judgments or the pronouncements. Then erosion of public faith, negative economic impact, for example, liquor ban and all those things. Done. Then define the complete justice, sense of complete justice, bring out the white paper. What is bring out white paper? Discussions. Do more debate, see whether can we limit the powers or not. है ना? Make some guidelines for the Supreme Court to use the Article 142. Then reference to constitutional bans and establishing guidelines. All these are nothing but the way forward. This is homework यार, but I am doing it for you so that थोड़ा बहुत idea लगे. बाकी खुद ही पढ़ना है, ये homework लिख लिया आपने ऊपर, है ना? These three cases you will read. First, second, third. The Supreme Court said that it could depart from procedural as well as substantive laws, but they need not to follow the law if they are giving the verdict under Article 142. Under Article 142, they don't even need to follow the law. Ashok Sadarangani versus Union of India, that it must be circumspect about the power under Article 142 and exercise it sparingly. हमें कम use करना है. They have themselves cited. Then Supreme Court Bar Association, the use of Article 142, the court referred to the provision as a valuable weapon in the hands of court to prevent clogging or obstruction of the stream of injustice. है ना? So these three judgments, along with some examples, the ideology of Article 142 will do the wonders. If the question is coming directly on Article 142, it has been in news since last 2 years. Maybe this year or maybe next year it can come. Okay? Next is judicial accountability. ज्यादा भूख तो नहीं लग रही है? कितने लोगों को बहुत ज्यादा लग रही है कि बैठ भी नहीं सकते 15 मिनट? जाओ फटाफट खा के आओ, पाप मत चढ़ाओ मेरे ऊपर. वी आर मीटिंग एट 3. But please come to the class on time so that you don't miss the important topic. Otherwise आगे वाला उड़ने लगेगा. ठीक है? क्योंकि देख रहे हो ना, frameworks we are using and we are closing a topic. If you are not coming on time, आगे वाला गया. अच्छा, one more thing online. Sorry, online, offline जाओ. The class will start on a new link from now. There will be a new link which you will be getting in your Telegram channel, the same Telegram channel of Vajra. So the class will start on that. Okay. We kept this class as the what is the public class, just to ensure that it can work as a demo also, and various other aspects. So from now the class will be on the private link. Thank you.